All right, there. How's it going? This is going to go on the YouTube page for Lorraine County and City Politics Uncensored. Aaron Knapp here from the neighborhood social worker and whatever you want to call me, activist, um, change agent, however that looks. Today's video is going to be like it's been pointed out to me, and I recognize I'm pretty wordy, I'm pretty lengthy. I put a lot of information down that people don't want to read, and I some of this stuff you just have to take in its entirety. I can't cut it down for you because the arguments are always, well, why? Well, why? Well, this is the why. So what I'm going to do here is I'm going to read the citizen's narrative form. It's quite long. I'm going to try to do it all in one session, but I might break it up because it's 138 pages with evidence. But this is the narrative that I wrote in regards to charging James McCann. And so I just want everyone to understand. And again, I get it. Everyone thinks I'm incessant. I am. I'm not letting this go. He took away my job. He attacked my person, my ability to work. He attacked my reputation. And he took away my ability to feed my child. I mean, I don't see anyone else that wouldn't do the exact same thing. And again, no justice. So here's the narrative that I wrote, and we'll just go from there. Citizens' narrative. So the following document is a statement of events and a request for this report to be sent to the prosecuting attorney for review for possible prosecution of the individuals listed. Possible. As the party who was the victim of these actions, I write the following account of the events under no duress and of my own free will, and I do swear following is an accurate accounting of events as they occurred to the best of my knowledge. I will attempt to break the report into abbreviated sections that they can be explained in further detail upon investigation by law enforcement upon request. I shall lay the document out in chronological order and attach the proof of allegations and evidentiary attachments to be referenced as exhibits in the report. I do not make these allegations lightly, and I am deeply disappointed that I am required to do so. Below is an accurate accounting, to the best of my knowledge, on hand at the time of this report. So, my first interaction with Chief James McCann with the Lorain City Police revolved around a civil matter, a rights matter that occurred over one of his officers denying entry to Rockland on the River to my service animal. I start with this incident because the chief made a statement in an email dated 8/24/2021 where he said, and I have this email, he said, quote, "I always take complaints seriously, but understand I cannot be involved in every aspect of this department or I wouldn't need a command staff. Please take your time and send me a well-written email detailing your complaint and include the date, the time, the officers' names if you know them. Take care." That's Exhibit 1. So again, this statement will be very important in establishing motive and intent as we progress in the report, as it's being stated as being stated now for that reason. This statement will be very important in establishing motive and intent as we progress in the report, so it is being stated now for that reason. Sorry, I just wanted to reiterate that. Moving forward to around March 21st of 2022, I believe it was, where I, Aaron Knapp, made contact with Chief McCann and the Lorain City Mayor Jack Bradley and others via email, where I was criticizing the department's shutting down of the city's Facebook pages, comments, and their handling of the incident on West 27th Street as being inappropriate. So, in the chief's response, he said, in the chief's response to me, he stated things like, quote, "LPD cannot react to an incident on social media until we properly investigate that incident, or we would be accused of being reckless. As chief, I am well aware that a government agency operating a government social media page is subjugated to legal and constitutional constraints with regards to page management. This is not, nor will it ever be, an issue for me. What is an issue is the public is under no obligation to post honest and informed content." That's true. Again, and this is not an issue for me. However, harm to the reputation and in extreme cases, the physical well-being of Lorain Police and City of Lorain employees, as well as the organization themselves, can and has resulted from the misinformation and inaccurate posts on these social media pages. I have personally been recipient of threats against myself, my family, and my property. Though I am confident in my abilities to protect myself and my family, I am not okay with the LPD social media accounts being used to convey these communications or to spread the misinformation via public comment that serves as a basis for these threats. To be clear, I, James, am willing and ready to stand in front of a federal judge and state my case. That's Exhibit 2, as I state on the record here. As well as, he stated, quote, at this time, we have not been able to find any case law that specifically addresses any issue concerning our social media account and the actions we took to calm things down during our administrative investigation. There is, however, specific case law that does address deleting an individual's comments and or deleting or blocking an individual. If you have specific case law that deals with LPD social media management decisions, I would be happy to review it. Additionally, courts have stated, as has the ACLU, that off-topic comments can be removed from a post. In other words, if there is a post about a basketball game, a comment talks about a football game can be deleted. This, of course, is very time consuming. That's also Exhibit 2. Sorry that I keep looking over here. I have the video. I'm videoing here, but the camera screen is over here that sees me, and so I always kind of just naturally grad group that way. So now it says, I would be remiss in pointing out, this is me, I would be remiss in pointing out that if he is well aware of the policies governing social media pages, why does he need me to provide the case law? But as you will see, I did provide that case law in subsequent emails as per his request, Exhibit 3. Also sharing with me that he had received death threats as law enforcement matter and should have been an ongoing investigation I should not have been privy to. Right. So just let that sink in. Why is he sharing that with me? Now, on April 10th, I received the following email in response from James McCann in response to a complaint that I had said someone contacted my employer to the mayor. I complained to the mayor. The statement will be important as to motive and knowledge later in this report, in which Chief McCann wrote, if someone called your place of employment in their official capacity from the Lorain Police Department, they were not authorized to make any such phone call or notification. I'm going to pull this up. That's not going to work. I was trying to blow it up a little. If you have proof of this accusation and the name of the employee, please forward that to me and it'll be investigated. If it can be determined that a member of the police department in their official capacity called their employer, I will address it. You filed your complaint with the U.S. Attorney's Office, not with the Lorain Police Department. That matter is in their hands, Exhibit 2. I did file a complaint with them. I filed a complaint with quite a few people that don't get back to me. On May 8th, I received a response from the Chief McCann stating that, and I quote, first off, I will address your email from May 7th, 2023 at 0800 hours. I feel the need to help you understand what a public record actually is. This is so funny. According to the Ohio Revised Code, a public record means any document, regardless of physical form, including an electronic record created or received by or coming under the jurisdiction of any public office which serves to document the activities of the office. You have asked for any public records in your email. You have asked for legal advice, which we do not give. Your questions should be directed to your attorney. Second, I will address the complaint you filed on May 8th, 23. There is no violation of law. We are within our rights to release the information. The complaint will not be investigated. It is your right to file a lawsuit, but I would strongly suggest you speak to your attorney and ask him to explain the consequences of filing frivolous lawsuits and the potential repercussions that can come from them. Quote, no one here believes a simple forwarded email with no additional comment is a public record, comma, but I will also include that as a PDF, Exhibit 4. It is. On 6/24/2023, James McCann sent an email and correspondence to Aaron Knapp, and he CC'd the executive officer, A.J. Mathewson, the following. Mr. Knapp, below are the answers to your questions. Okay, well, at minimum, I would think that I would have access to the new policy as it was read to me via the phone about the entry at City Hall. He wrote, as it is a policy, or I wrote, as a policy, it shouldn't be restricted, I guess. He writes, the Lorain Police Department is not in charge of the security protocols for City Hall, nor do we make the policy for City Hall. The Safety Service Director is in charge of City Hall. And for the record, I'm not sure how access to public lobby videos would be privy to protection under this law, I said. That being said, can you give me a time frame on when they will be available? As you have 30 days to complete your investigation of the lieutenant placing his hands on me, I assume you'll receive them then. You are entitled to your opinion, he says. During an active criminal or active administrative investigation, we believe the video evidence is not public record until the investigation is complete. If you disagree with us, you have that right. You also have the right to file whatever action you desire. Just to be clear, the 30-day deadline is an internal policy that I set as a general completion goal, and it may be extended at any time depending on operations, complexity of the investigation, vacations, and the like. Well, then he should write that in his policy. Are you planning on charging him with a crime? Because as I read here, as I am the subject of the video, I have a right to have access to his body-worn camera regardless of your investigation into the LT's action. He said, the administrative investigation is ongoing. Again, we believe video evidence is not a public record until the investigation is complete. Okay. The last comment about an administrative investigation being ongoing in public records until and not a public record to be completed is also very important, as later this very report was sent to a civilian via email prior to the investigation being completed. That's the problem. You see how this works? See how this works? So on or around the late May, Chief McCann filed a complaint against my state license to practice social work on behalf of the Lorain Police Department. I know this, I can't see the complaint, but I know it because they said, what did you do to piss the chief of police off so bad that he figured out we had a board and then filed a complaint? It was like a first for them. But he filed a complaint against my state license to practice social work in late May, on behalf of the Lorain Police Department. For signing, he said it was for me signing my name with LSW, which I am a licensed social worker, to my emails and stating that I was, quote, an officer of the court. On May 9th, contact, Exhibit 5. I felt it was inappropriate for myself and the chief to have continued contact at this point, and I sent him several emails asking him to cease all contact with me. On June 21st, 23, I sent the following email to the chief in response to his continued email announced communications, and I asked him to stop. This is the email I sent on 6/21 where I asked the chief to stop all communications with me, and I quote, please, I will ask you once again not to email me. If you wish to communicate with me, I'd appreciate it if you would place said communication into writing and mail it to me. I'm not sure why my request to records would be subject to a response from the chief. If you are referring to the state investigation into my license, I see no law preventing me from having that email, as you are not that agency and you did send it. But if you wish to hold off until the board is done, by all means do so. As Captain Mathewson reviewed those policies with me and read them to me over the phone, the department obviously received the memo on security. Therefore, it's part of the internal records and was sent via email to me at least two separate sent via email to at least two separate captains who read it verbatim to me. So I'm not sure why you are being so secretive about all this stuff. But in the future, if you have to email me, I would please request that you have Captain Mathewson respond. He has been respectful and responsive, and I think it is a very bad idea for both of us to have continued conversations. So please let the officers do their jobs and respond to me. I'm trying to follow the appropriate procedures here, and that requires I send those emails to the appropriate people. You make it a wonderful day as well. Aaron Christopher Knapp. He wrote, make it a wonderful day, copy in my email sign off. He responded with, Mr. Knapp, Thank you for your response. Email is my chosen form of communication to reply, and all of the public information requests I receive from everyone, so this is what you get. You get the response from me because your requests are not the type of requests that our records employees handle, and I will be the only one to respond to your request from now on. Our records employees do not have access to email records, videos, or other administrative files, so the requests are all forwarded to my office. It's great that Captain Mathewson reviewed all City Hall policy with you. However, the policy is not ours to release to the public. The policy was issued by Safety Service Director, and that is whom you must request it from. If we were trying to be secretive about the policy, I wouldn't have told you where to request it from. Whatever. Finally, you don't get to demand who you talk with at Lorain PD. I get to make those decisions, so I will be the only one communicating with you from this department in the future. Have a great day. Just for the record, that was a straight lie because I've spoken to many people since then. And also, it was also illegal, and discriminatory. And he works for us, not himself. You work for us, dude. And again, we go back, as I would say here in the thing, if we refer back to the beginning of the report, the statements the chief made were very important. Here, 2 years later, this is why I save emails, folks. 2 years later, he wrote me that email after he wrote, I take these complaints seriously, but understand I cannot be involved in every aspect of this department or I wouldn't need a command staff. Please take your time and send me a very well-written email detailing your complaint and include the date and time and officers' names if you know them. Take care. Exhibit 1. I mean, so if his chosen form of communication does not matter. I was sending my emails to the Lorain complaints email, and Captain Mathewson had already been designated my contact point, so why the change? Either way, I asked him to stop, and he refused. And Section 2917.21 of the Telecommunications Harassment, Ohio Revised Code Title 29, Crimes Procedures, Officers, Public Peace, blah, blah, blah. It states that knowingly makes telecommunications to the recipient of the telecommunication to another person at the premises in which the telecommunication is made, or to those premises, and the recipient or another person at those premises previously has told the caller not to make telecommunications to those premises or any person at those premises. Whoever violates this is guilty of telecommunications harassment, a violation of division, and then it lists a bunch of numbers, and it says it is a misdemeanor of the first degree on a first offense and a felony in the 5th degree for each subsequent offense. So, under this law, the first response on 6/20/21/23 would be offense number 1. There were at least 2 plus more responses buried in the chain of emails once he was asked to cease electronic communications with me. I had emails from August 1st and August 16th that I did not reply to the chief, or reply to from the chief. That would make the second 2 offenses felonies in the 5th degree each. All of this stated the chief refusing to remove protected public information from the Lorain Police Department website. It's still up to this day in 2024, guys. After reporting this to numerous individuals who agreed juvenile court documents and pictures of juveniles, especially those not subject to arrest, are not permitted online. I wrote an official complaint to the department asking them to remove the offending documents, but they refused, and to date, the mayor of Lorain, Jack Bradley, and the chief both claim they have the right to post juvenile information publicly online, not to mention the teachers' names and protected FERPA documents that they have posted to boot. Here is the kicker. Those are not my kids. And as such, I cannot sue civilly on behalf of the parents. But as this is a matter of public concern, I can't advocate to get the information removed, as it is still illegally online, unredacted. My statement is, if the chief believes he has the right to share the Hildress information publicly, why wouldn't he share my child's information? Why wouldn't he share yours? So fast forward to our current state, and Chief McCann has submitted over 61 pages of emails, complaints, confidential administrative screens, address, phone number, last 4 of my social, my child's name, everything via unredacted, unsecured email, public email to Tim Weitzel, the juvenile court administrator. See Exhibit 7 of this report. I'll be putting a link to the report down in the video link in case you want to read through the long and wordy thing that I'm reading to you now. In the first email, he says, I'm keeping this. All right, no, sorry, my bad. Tim, keep this close to the vest as this is still under investigation. Right there. So is Tim Weitzel a police officer or a prosecuting attorney? He's not. He's a master level social worker who runs juvenile justice in Lorain County. Does he have access to Lorain police records on call? And should he receive documents from the Lorain City's police chief illegally, as they contain witness information as well as my information? And under the law, I am considered a protected individual. I thought at the time, as I'm working as a social worker in juvenile justice. So sharing all my private information was illegal under the following laws I stated. And then I list section 149.43, availability of public records for inspection and copying. It goes through all the lists on, I'm not going to bother you with that because I guess that's probably, the stuff that you don't want to hear, but it's in the file. I'll link it. Section 2921, offense against public administration, general definition. But again, we go down to the chief himself stated in regards to the investigation concerning City Hall. He said, Mr. Knapp, due to an ongoing administrative investigation, the records you have requested are not currently subject to disclosure. As such, records are confidential law enforcement investigatory records pursuant to RC 149.43A1H. Your request is hereby denied. Okay, that's Exhibit 6. So when Chief McCann sent the 61 plus documents in Exhibit 7 to Tim Weitzel, the social worker who's in charge of juvenile justice at the courts, he was utilizing email not only commit retaliation, which is crimes of procedure, offenses against justice and public administration. No officer or employee of the state of its political subdivision shall knowingly release, discriminate, or disseminate, or make available for any purpose involving employment, bonding, licensing, or education to any person, to any department, agency, or instrumentality of the state or any of its political subdivisions, any information or other data, any arrest, taking into custody, complaint, indictment, information, trial, hearing, adjudication, or correctional supervision, the records of which have been sealed pursuant to 2151.356 of the revised code, and the release, dissemination of, making available of which is not expressly permitted by this section. Whoever violates this division is guilty of divulging confidential information and a misdemeanor in the 4th degree. And then it goes on to talk about, no person shall by force or unlawful threat or harm to a person or property shall retaliate against a public servant, a party official, or an attorney or witness who is involved in a civil or criminal action of a proceeding because the public servant, party, official, attorney, or witness discharge the duties of a public servant, party, official, attorney, or witness. No person purposefully and by force or unlawful threat of harm of any person or property shall retaliate against the victim of a crime because the victim filed or prosecuted criminal charges. Whoever violates this section is guilty of retaliation of felony in the 3rd degree. And then he also committed telecommunications harassment of Mr. Knapp through another individual. So by communicating with Tim Weitzel, after I told him not to communicate with me and I blocked him, he messaged Weitzel and violated, this being Chief McCann, violated section 2917.21, telecommunications harassment, knowingly makes the telecommunication to a recipient of the telecommunication or another person at the premises to which the telecommunication is made, or to the premises and the recipient of another person at those premises previously had told the caller not to make telecommunication to those premises or any other premises. So knowingly incites, this is the important one, section 10. Knowingly incites another person through a telecommunication or other means to harass or participate in the harassment of a person. So when the chief sent the email to Tim Weitzel, section C1 states, whoever violates this section is guilty of a telecommunications harassment. And a violation of this section under section 2, it states, of this section is a misdemeanor of the 1st degree on the first offense and a felony of the 5th degree on each subsequent offense, which we've already talked about. The key part is I lost my job. It cost me approximately $12,800 in salary. That's not counting benefits and finding new work. So read this part carefully and then look back at what the dollar amounts due to these charges. Section 3 says, except as otherwise provided in Section C3 of this section, it is a violation of Division A4 of this section is a misdemeanor of the first degree and on the first offense, and a felony of the fifth degree on each subsequent offense. If a violation of Division A4 of this section results in economic harm for $1,000 or more, but less than $7,500, telecommunication harassment is a felony in the fifth degree. If a violation of Division A4 of this section results in economic harm of $7,500 or more, but less than $50,000, telecommunications harassment is a felony of the fourth degree. If a violation of Division A4 of this section results in economic harm of $150,000 or more, telecommunications harassment is a felony of the third degree. Now, as I will attach exhibits to this report, I will include the other laws that may be applicable to this report and or crime, and I will expect any questions will be asked and answered during the investigation into this matter. So basically what that says is caused economic harm of $7,500 or more, but less than $150,000. It's telecommunications harassment. It's a felony in the fourth degree. So, and it should also be noted that the receipt of the emails, Tim did not keep it close to his vest. He acted on it, and shortly after, without verifying that Mr. Knapp was a guardian ad litem, and under the Lorain Court's own website, was considered an officer of the court. He had Mr. Knapp's ability to contract with the courts terminated for supposedly, quote, misrepresenting the court. And exact same thing McCann stated. And also shared this information with other employees in the court, such as Tim Green of Voices for Children, and instructed him to not speak to me or allow me to volunteer with the courts. Again, more illegal actions on evidence that arguably was fruits of the forbidden tree and should have been immediately reported to the courts once received by the chief, from the chief. The it states the court's website states Gal volunteers complete 30 hours of pre-service training, which includes 4 classroom sessions, 30 hours, and courtroom observations. All gals are screened, interviewed, and a criminal background check done through WebCheck system is completed. The judges administer the oath, and the volunteers are then recognized as officers of the court. In addition, there is a continuing 12-hour education requirement annually, which I finished the class and already satisfied the 12 hours right after. It is misconduct and grounds for discipline if the guardian ad litem to violate or attempt to violate the rules or statutes governing guardian ad litems, a guardian ad litem or an appointment order issued pursuant to them, or knowingly to assist, influence another to do so, or to, through the acts of other, engage in conduct that violates the applicable rules for conduct of a guardian ad litem in another jurisdiction, commit any criminal or unlawful act that reflects adversely on the guardian ad litem's honesty, trustworthiness, or fitness as a guardian ad litem, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, have allegations of abuse or neglect against him or her substantiated by against them, fail to maintain compliance with requirements for placement on the roster regarding that item. It's just, it should be noted that social worker board found, and so in the end, I mean, that kind of goes on for a while. Willfully violate this order, imposing discipline on guardian ad litem rules, or willfully fail to comply with the subpoena, fail to comply with conduct, best conflict of interest, or mandatory disclosure requirements in guardian ad litem rules. It's basically an ethical quandary. But it should be noted that the social worker board found I acted ethically. I included that as Exhibit 8. It should also be noted that the Ohio Department of Unemployment found I acted appropriately and did not violate ORC. That's Exhibit 9. And then I list a bunch of laws you can reference that really are gonna clarify everything. But if I were to sit here and read them all off to you, you'd probably doze off. So we'll kind of just get past all of that. Um, and then I signed it. I hereby affirm my knowledge is the best of my knowledge is true. I also basically said I want to file criminal charges against Chief McCann as he was acting under color of law when he committed the acts of harassment. It says he was not acting under color of law, and he was, nor was his act of harassment, nor was he acting under color of law when he released all the information to my contract holder. I wish charges to be brought against him, Weitzel, because although he received the emails apparently unrequested, he did not, or he did act on the knowledge contained within them, and as such, continued Chief McCann's harassment of Mr. Knapp. He also forwarded the information to Tim Green, or at least made him aware, who then stated Aaron could not volunteer as a gal for the reasons plural you were told when you were unable to contract with the court, which is also retaliation and conspiracy. He should have never given the reason I was let go from the court to Tim Green, the GAL guy. These types of behaviors of public servants are counterintuitive and are not legal. If you see something, say something. Well, I am saying something. Please feel free to follow up with any questions. And then it just goes on to list all the emails and all the exhibits and everything that was ever said and done in this process. I just, again, you can say what you want, but Chief McCann got butthurt because I made some complaints. Chief McCann sent those complaints to the social worker board. They laughed when they called me. They said, "What did you do to piss the chief of police off so bad that he figured out we had a board and then bothered to make a complaint?" Now, while they can't send me the complaint, that's what they said. So I knew who made it. Chief McCann never denied it. When you look at his emails, he clearly states he was in direct contact with the investigator. So on behalf of the Lorain Police Department, without checking with anyone else, he went after my state license. That in itself should be an ethical quandary and violation enough. He utilized color of law, and his name is chief of police. Now, I may not be able to see that that complaint, even though technically I should, because if he sent it via a public server, even though they're not allowed to release it to me at the NASW, because he sent it via unredacted, unsecured email, it should be available to me unredacted because it has all my information and no one else's. But that being said, someone should investigate that complaint. Find out if he sent it from a city email address. Did he have the right to do so? If so, he made the city liable. This is what I'm talking about, folks. You can complain all you want. You can tell me to let it go all you want, but I'm not gonna. I'm just not. I went to the county prosecutor's office and got harassed there. I went to Ray Carrion and he lied to me. To this date, he's never set the magical meeting up he said he was going to set up. And shortly after getting on my porch and me sharing all this information with him, he left and took a job with the city and then investigated James at a minimum because I gave him all this information as my ward rep and as my representative. The second he tried to investigate on behalf of the city, he should have recused himself. So again, you got these problems. Now I see this whole situation with the law department and the mayor of Sheffield Lake and the city council and the police department of Sheffield Lake. Like, you guys can be mad at me all you want. I didn't write these laws, but I read them. And the one thing I can promise you is I'm going to keep reading them, and I'm going to read everything that comes before me in city council, and I'm going to do everything that I can to make things right for people. So I'm not doing it because I'm vindictive. I'm doing it because I'm driven, obsessed, whatever you want to call it. But I have ADHD, I have PTSD, and it drives me once something's stuck in my brain. And injustice is something that I can never abide by. And as a disabled veteran, I can no longer physically fight injustice, but I can do it this way. So again, that's the citizens narrative form that I filled out. At some point later, I plan to release the or do the same thing with my response to the Board of Social Workers. But you know, I've written numerous letters and numerous things, and I'm going to post the link to this page in the comment section below. So hope you guys enjoy, and make it a wonderful day.